Hello and welcome. This installment of our PowerPoint narratives will be focused on criminal law and business. And again, the overall context is the legal and regulatory environment of business. So this is another chapter in our studies for the textbook and the course. And we're not going to cover all of the material within the chapter, but certainly I'm going to highlight, in my opinion, some of the more prevalent or larger points, if you will, that will warrant our discussion and our further class focus. Let's talk about criminal conduct generally. Criminal conduct is extremely destructive and costly for business. Fraud has reached individuals in business settings as well. So it's not just, for the business or the corporations or the partnerships or the limited liability companies. And by the way, those are all terms for our next study involving the different forms of business organizations. But it relates in terms of the criminal conduct to even individuals in business settings that have been exposed to and suffered from criminal conduct aimed at affecting them by others. Bernie Madoff, for example, the energy firm of Enron and WorldCom are all examples of how criminal conduct is destructive, costly for not only business, but also individuals who are impacted by their criminal behavior. Let's talk about the term white-collar crime. White-collar crime. White-collar crime relates to crimes committed in the business context. The authors of your textbook comment that white-collar crime cost businesses over $100 billion each year. I want you to take a look, if you can, or you probably have already read through this assigned chapter, but table 13.1 in your textbook, examples of white-collar crimes. And I'm just going to list a few of these here that all are good examples of this type of crime that impacts or is affected within a business environment. And that would be accounting fraud, or bankruptcy fraud, bribery, conspiracy, aiding and abetting, counterfeiting, embezzlement, false statements. In one of your assigned, not in your readings, but in one of your assigned board commentaries will be an example of false statements. Forgery is a crime. Income tax evasion is a crime. Insider trading is a crime. Kickbacks, larceny, mail fraud, obstruction of justice. We're going to talk about obstruction of justice in just a short while. Price fixing can also be a crime. Later in this course, we're going to talk about antitrust violations, where we'll spend some time focused on aspects of price fixing within that context. Racketeering, wire fraud. There's a lot of examples of white-collar crimes, and of course, these crimes impact business. Let's talk about two very common terms in the criminal context, and that would be felonies and misdemeanors. You've probably heard of these terms before. Crimes are classified as either felonies or misdemeanors. Felonies are punishable by fines or imprisonment for a period of 1 year or more. Misdemeanors are still crimes, but they're lesser crimes, and they are crimes that are committed that have lesser value, lesser economic value or impact than those involving felonies. Misdemeanors are punishable by fines or jail sentences of less than 1 year. Less than 1 year. So major crimes are going to fit into the category of felonies, and minor crimes, if you will be misdemeanors. And those distinctions will be regulated and defined based on the state law of each particular state. Not every state is going to have the same definitions. Most will have very similar ones, but each state, through their own autonomy, will have their own criminal codes, and that's really what has to be drawn from. And the source of that is, of course, the legislature. Felony cases are commenced by a grand jury indictment. You may have heard the term indictment or to be indicted. It's when the grand jury is convened, they're presented with information, evidence that warrants a trial at some point. And if there's enough cumulative evidence, then the grand jury may issue what's called an indictment. Misdemeanor cases are usually commenced when the government files a charge called an information. And when I refer to the government, it would be the state's attorney's office, for example, in a given county in our jurisdiction here in Illinois. And there's other terms that may apply to other states as well. A grand jury determines really if there's enough evidence to warrant a trial where there's allegations of conduct that could amount to a felony. Let's talk about the Constitution. I mentioned earlier in this course when we examined the Constitution with respect to the legal and regulatory environment of business that we're also going to revisit the Constitution when it comes to the section on criminal law. Well, because the Constitution has great application with respect to the rights of individuals, certainly in a criminal contextual setting. The Fifth Amendment to the Constitution provides that before anyone can be tried for a capital crime, there must be a presentment or indictment by a grand jury. For an indictment to be returned, a majority of the grand jury must provide that a crime, must find that a crime has been committed and that the evidence is, as we mentioned earlier, sufficient to warrant a trial. And this determination is called probable cause. That cause is indeed probable to suggest that a felony was committed and that a crime should be prosecuted and that the defendant stand trial. Let's talk about the term presumption of innocence. And this is a huge term with respect to our legal system, in particular the system here in the United States. In our legal system, even an indicted person is entitled to a presumption of innocence. This is profound. Truly, this is profound. One is presumed innocent, not guilty, but innocent until proven guilty. So, even a person who's standing trial throughout the entire proceeding is cloaked with this presumption of innocence. It's not until the judge or jury returns a verdict or a determination of guilt does that presumption let go or is released. So make sure you have a good understanding of this concept. It's fundamental to our legal system and to our theory of jurisprudence. Now, with criminal law, the core concept in our jurisprudence is intent. Intent. We've talked about intent before. We've talked about intent that can be established through the objective reasonable person standard. And I'd mentioned to you when we examined contract law and tort law about these standards and how intent was certainly going to be a matter that would have later application in our studies relating to criminal law. Well, here we are. We're now talking about intent with respect to criminal law, and it is a core or fundamental concept. A crime is committed with the conduct, that's the action that's carried out with or by intent. Intent is revealed by a voluntary and knowing aspect. A voluntary and knowing aspect. In other words, you have to have some comprehension or recognition of what conduct is actually being undertaken. It's not undertaken by accident. It's undertaken through some voluntary, affirmative action with knowledge that such conduct is in fact underway. In some criminal cases, recklessness is sufficient to prove a crime. In other words, the conduct is so reckless that there's a disregard of any safety whatsoever or disregard of any outcome, that the aspect of recklessness will still be sufficient to establish a crime was committed. A good example may be reckless driving. Reckless driving. If someone is so reckless in their control and operation of a motor vehicle that someone is later struck and harmed, then a crime may also be committed, and the defendant would be prosecuted. Reckless disregard for the truth is often a basis for white-collar crimes. Let's talk about the criminal burden of proof, and let's compare that criminal burden of proof to the civil standard for burden of proof. And we've talked about this also in the past during earlier segments of our course studies. Unlike the civil standard for burden of proof, which is preponderance of the evidence, for the criminal standard, it's beyond a reasonable doubt. Beyond a reasonable doubt. It's not any doubt, but a reasonable doubt. And note the difference. Any doubt is different from a reasonable doubt. So beyond reasonable doubt is the standard. So if we were going to use, for example, let's just use a football field. What's in the very middle of the football field? It's the 50-yard line, and opposite the 50-yard line on each of the fields would be the end zones. And we said that for a preponderance of the evidence standard in civil law, it just has to be a more likely true or more likely than not standard. So you get across that 50-yard line toward the other end zone, and that may be sufficient. That may be moving in a direction where there's a preponderance, a more likely than not standard. When it comes to the criminal standard of reasonable doubt, you've got to be awfully close, so to speak, to that end zone, far away from midfield, for there to be a reasonable doubt territory. Now, it doesn't mean, for example, using the same metaphor of a football field, that the evidence has to be clearly within the end zone for there to be that type of standard. But it's certainly much further down the way, or down the field, so to speak, toward the other team's end zone than right across the 50-yard line, as the civil standard so has been used with this metaphor of mine. Hopefully that makes sense. We can certainly talk about that in much more detail during our weekly sessions, or please feel free to give me a call or email me, and I'll be pleased to expand upon that in much more detail. Again, let's go back to the Constitution, and we're going to talk about the Fourth Amendment. The Fourth Amendment prohibits illegal searches and seizures. The Fourth Amendment protects persons and corporations from unreasonable searches and seizures by the government. We're going to talk next week about different forms of business organizations. And you're going to learn that in the eyes of the law, a corporation is considered a person. A person. Just like a human being is a person, in the eyes of the law, a corporation is also a person. So it's consistent then that the Fourth Amendment protects persons and corporations from unreasonable searches and seizures by the government. Unwarranted intrusions on their privacy by the police or other governmental agencies would be prohibited unless a search warrant is obtained. You've probably heard the term search warrant many, many times. It's a form of a court order. A search warrant actually is a court order authorizing that search of one's property. The protection of the Fourth Amendment really provides an expectation of privacy. Now, that term, expectation of privacy, we've already discussed and studied. But the Fourth Amendment, as it applies to governmental action against persons, creates that expectation of privacy in this sense. Again, let's look at the Fourth Amendment. Employees of some businesses, however, do not have a Fourth Amendment protection because of public policy, as the courts have so determined. For example, alcohol and drug testing, which is an intrusive measure, can, for example, be required, and depending upon the context or the employment, based on public policy needs. Alcohol and drug testing of railroad employees and airline pilots are not violations of the Fourth Amendment, according to the courts. There is an exception. Fourth Amendment exceptions that I want to point out would be that the police sometimes, even in the absence of a warrant, can conduct a search. So police may sometimes act without a search warrant when there is an immediate risk to public safety or a risk of lost evidence. Now, of course, this is a very general description. There's a lot of specifics to that exception and a lot of nuances to it, but for our purposes, I just wanted to make that known, as did your authors in your textbook. Let's turn to Miranda rights and take a look at sidebar 13.4 in your textbook. Miranda was a decision by the Supreme Court in 1966. And if you're interested in learning more about the Miranda case, I'd encourage you to do some research. It's an interesting case. The Supreme Court considered a lot of information with regard to what occurred in that case, and ultimately provided that there are certain inherent rights that individuals have, which later has been termed as Miranda rights. There has to be a warning, and you've heard this warning probably in numerous TV shows that you've watched, and you're probably well familiar with some of these warnings, having watched TV, grown up listening to them, but it's all based on a Supreme Court decision that originated back in 1966 involving a defendant. So the warning of the rights, and this is right out of your textbook, would be that you have the right to, textbook, in other words, from the case law, but in your textbook on page 397 or 387, whichever version of the textbook you're using, there are these rights that are set forth there for your reference. You have the right to remain silent and refuse to answer questions. Do you understand? So there's a request of acknowledgement for understanding. Anything you say may be used against you in a court of law. Do you understand? Again, the request for acknowledgement of understanding. You have the right to consult an attorney before speaking to the police and to have an attorney present during questioning now or in the future. Do you understand? If you cannot afford an attorney, or one will be appointed for you before any questioning if you wish. Again, do you understand? If you decide to answer questions now without an attorney present, you will still have the right to stop answering at any time until you talk to an attorney. Do you understand? Knowing and understanding your rights as I have explained them to you, are you willing to answer my questions without an attorney present? So the law is extremely protective, and the law wants to make certain that if there's going to be any type of disclosure by way of examination by the police or some form of confession, that there be these acknowledged warnings and stated understanding. Otherwise, even if there is a confession, even if there is information that's gathered that leads to the prosecution, the outcome of that prosecution could be set aside if the Miranda rights were not properly administered or there weren't any to begin with that were administered. So please make sure you have an understanding of the Miranda rights, and I just read that section from sidebar 13.4. Let's again talk about the Constitution. This time we're going to focus on the Fifth Amendment. The Fifth Amendment. And again, this is probably an amendment that you've heard mentioned many times, and we talked about it a few weeks back in the Constitution section for the course. But this is a privilege from the amendment against self-incrimination. The privilege against self-incrimination protects the accused of being compelled to testify against oneself. In other words, against one's own interest. The Fifth Amendment, however, sorry for the interruption, so we're back on the narrative. The privilege against self-incrimination protects the accused of being compelled to testify against oneself. The Fifth Amendment, however, does not protect the accused from being compelled to produce real or physical evidence. So really the focus is on testimony. The protection against compulsory self-incrimination under the Fifth Amendment does not also apply to corporations, including professional corporations and partnerships. The types of business described above have no Fifth Amendment right to refuse to submit their books and records in response to a subpoena. And we know what a subpoena is. That's a form of a court order compelling the production of whatever has been requested, what documents or material constitutes evidence that is being sought. The only business protected by the Fifth Amendment privilege against compulsory self-incrimination is a sole proprietorship. Now, those are terms that we're going to talk about when we examine the various forms of businesses in another segment, not today, but in another segment of our PowerPoint presentations. A closely held corporation with only one shareholder is also not protected by the Fifth Amendment. The Fifth Amendment provides also that no person shall be subject for the same offense or to be tried twice, or to be twice put in jeopardy of life or limb. Courts do not allow individuals to be tried twice by the same governmental entity for the same crime based on the same factual situations. To do so would violate the Fifth Amendment double jeopardy standard. And you've probably heard that as well. Double jeopardy It originates from the Fifth Amendment, and hopefully this explanation is clear. Let's talk about the Sixth Amendment, rights in a criminal case. The Sixth Amendment allows for the following rights: a speedy and public trial, a trial by jury, the right to be informed of the charges and to confront the accuser, and to subpoena witnesses, along with to have the assistance of an attorney. So all this is found within the Sixth Amendment to provide for rights in a criminal case. Let's talk about fraud. And we've had discussion about fraud earlier in the course in the civil context. Both fraud with respect to contract law and fraud with respect to tort law. Well, now we're going to examine fraud within the context of criminal law. Fraud as a crime is when there is a knowingly and willful concealment of a material fact or the false representation of a material fact, or to use any false writing or document knowing, again the term knowing, the same to contain any material false, fictitious, or untrue fraudulent statement. Even if fraud has not actually been committed, and I want you to note this distinction, it's a crime to scheme to defraud. When an individual commits an act with the intent to obstruct the legislative process or the judicial process, the crime of obstruction of justice can be present. It's often been said in the criminal process or criminal law process that the so-called catch-all for crimes that will be prosecuted is the obstruction of justice aspect. In your textbook, there are listed a number of individuals who have been prosecuted with the crime of obstruction of justice. That's in sidebar 1311, or 1311, I should say. Examples of successful prosecutions would be that of Louis Scooter Libby, who was the vice president of Dick Cheney's former chief of staff, convicted of perjury and obstruction of justice, and spent 2.5 years in prison. Martha Stewart, you may have some familiarity or knowledge about Martha Stewart. She was convicted for the crime of obstruction of justice and lying to investigators, and sentenced to 5 months in prison, 5 months before home confinement, and 2 years of probation. Kenneth Branch, the former Boeing company manager, pleaded guilty to obstruction of justice stemming from an investigation into the theft of sensitive documents from a competitor, Lockheed Martin. And then we also have Barry Bonds, very famous baseball player. Home Run King was found guilty of obstruction of justice for lying to a federal grand jury investigation into illegal steroid distribution. The law is very broadly worded and can encompass a wide variety of acts. So in general, any act made with the intent to obstruct the government's investigatory process may be a crime. So does all this relate to the legal and regulatory environment of business? That's been our question all along in all of our segments and in our discussion. In fact, this is the whole framework of your textbook, the legal and regulatory environment of business. All of these various laws shape and have some impact within this very general description, the legal and regulatory environment of business. So hopefully you found this section interesting. Thank you for your time and your continued attention and your hard work with this course. Thanks.